Welcome to this presentation on special allowance and its implications for pension eligibility. We will explore its legal, statutory, and administrative status and recent developments surrounding special pay for bank officers.
Special allowance was introduced for bank employees and officers under the 10th Bipartite Settlement, effective from 2012. It became a key component of monthly salary, but has raised questions about its pension eligibility. This slide presents a comparison between special allowance and special pay. While the former was part of salary without pension benefits, the latter, introduced recently, is fully pensionable, raising a strong case for parity and correction. Pensioners who retired between November 1, 2012 and July 31, 2024 were denied pension benefits on special allowance, despite it being universally paid, DA applicable, part of the regular pay and taxable. This exclusion caused widespread dissatisfaction. Now, let us go through the landmark judicial decisions that have clarified the legal status of special allowance in the context of pension and gratuity eligibility. First, the Uttarakhand High Court in Baburam Kashyap versus Canara Bank ruled in April 2024 that special allowance is part of pay and must be included in pension and gratuity calculations. The court emphasized that statutory regulations must prevail over joint notes or executive circulars. It upheld employees' rights under the Payment of Gratuity Act and pension regulations awarding 7% interest for delayed payment. In Bank of Baroda versus G. Palani and others, the Supreme Court reaffirmed that statutory pension regulations cannot be overridden by executive instructions. Pension is a vested, protected right, not a discretionary grant. The court reinforced that deferred wages like pension cannot be taken away without valid legal authority. High courts in Madras, Kerala and Madhya Pradesh, in cases such as G. Sundar Rajan v. Indian Bank, Murali Mohanan vs. Corporation Bank and Madhyanchal Gramin Bank v. AIG BPO, have uniformly held that special allowance qualifies as substantive salary and is pensionable. All these decisions establish a consistent legal principle. If an allowance is regular, permanent, universally paid, and attracts DA, it must be treated as part of pensionable pay. Courts look at the substance and nature of the payment, not its label. Substantive salary includes basic pay and any permanent, universally paid allowance, such as the special allowance, if DA is paid on it. It excludes temporary, ad hoc or performance-based components. Special allowance is permanent, regular and universally paid. It is backed by a wage settlement and attracts DA. It is not performance-linked or discretionary. Therefore, it qualifies as part of substantive salary. Judicial precedents across the Supreme Court and various high courts confirm that special allowance meets all criteria of pensionable pay. Principles like substance over form and beneficial interpretation support its inclusion. Courts focus on the nature of payment, not its label. The exclusion of special allowance, while including other components like FPP or PQP, violates Article 14 of the Constitution, which guarantees equality before law. This summary confirms that special allowance is monthly, universal, DA paid and wage settlement backed, meeting all conditions for inclusion in pension and gratuity calculations. In August 2024, SBI introduced a new special pay applicable to all permanent officers. Unlike special allowance, this special pay is pensionable, raising the question of why earlier allowances were excluded. Every component, FPA, PQP, FPP special pay, is DA paid, regular, and appears in payslips. The only outlier is the old special allowance, which is officially not pensionable despite meeting the same criteria. This chart highlights that all components, except the old special allowance, are currently pension and gratuity eligible. The newly introduced special pay meets all formal requirements for pension inclusion. The Indian Banks Association has sought to consolidate all related writ petitions in the Delhi High Court to avoid conflicting judgments. While legally valid, this move could restrict retirees' access to justice. Despite the interim order by the Supreme Court, new writ petitions can still be filed in any relevant High Court. The petition must highlight the personal hardship and local cause of action for retirees. Ongoing litigation does not prevent IBA or SBI from holding discussions. The sub judice rule applies to media and courts, not to policy dialogues. Legal precedents clearly support continued negotiations. To conclude, special allowance is permanent, regular, DA-linked, and part of the monthly salary. Legal, constitutional, and judicial grounds strongly support its inclusion in pension and gratuity benefits. Thank you for watching. If you found this presentation helpful, please like, share, and subscribe to Satya Videos. Stay informed, stay empowered.